Your business is your property, your asset, especially if it's a profitable business. So you need to think about these things. Take the time when you leave here today to go through just a list of everything that you own, everything that's an asset. Because if you're not here, someone's going to do something with that property, whether it's divided between family members, whether it's donated to Goodwill, whether it's whatever. So take the time to figure out what your assets are. And for everybody, it's going to be different. But it's a self-assessment. Where are you in life when it comes to property and your assets? Step 2 is to identify your beneficiaries. Who are the people that you want to leave something for if you're not here? And so, generally speaking, it's a spouse or your companion, your children, and I'll add bonus children. So in today's society, we have a lot of blended families. And so you need to make sure that you account for those blended families and those children that are part of your beneficiaries. And so it's going to be important if you have a blended family, if you have a will, you don't just want to say to my children, because if they're not biologically your children, and you have not adopted those children, they will not receive anything from that will. And so it's important to make sure if you have a blended family, you should be one, and that you account for them in the will, and just list out all the names of your children and your bonus children. I don't like the term stepchildren, but your bonus children. Your grandchildren, again, planning for your children's children. Your parents or grandparents, if they're still living, other relatives that you would want to be a blessing to if something were to happen to you. Your friends, charities. So are there any nonprofits that you're passionate about that you would want to give a donation to? Hubbard House, the Clara White Mission, anything like that, Big Brothers, Big Sisters. Are there charities that you would want to leave property to be a blessing to them so they can continue to carry out their mission? And pets. And also, I added this. I had a colleague to tell me, she's like, Amber, when you're out doing estate planning, you need to make sure that people that are pet owners take the time to have a plan for their pets. And I think she loves her pets more than people, and so she stressed this to me. So I at least wanted to mention it. In case we have pet owners, you know, those pets are expensive, so people treat them like they're children. And so what's going to happen to those pets should you pass away? And so being mindful of that as you're planning. And this is still a part of step 2, because depending on who your beneficiaries are, there are some unique or special things that you need to consider for them. For instance, if your child is under the age of 18, they're a minor, please don't write their name on the life insurance policy as the beneficiary. Don't leave a 5-year-old your $10,000 policy. Or don't put, I want my house to go to my 1-month-old. Because what happens is the court system has to step into place. You have to create what's called a guardianship account in order for the property to eventually get to them when they're at the age of 18. So a guardian would be appointed to manage that property or those assets for that child that's under the age of 18. What I recommend, and we'll talk about it more later, if you have children that are under the age of 18, what you need is a trust, which is another legal document. And so we'll talk about that a little more later, but I hear it all the time. I'm leaving this life insurance policy to my 5-year-old. Well, we hopefully don't pass away while they're still a kid, but they're not going to be able to receive it right out because they're under the age of 18, and so that makes sense. So those are special considerations that you need to be mindful of. Individuals with disabilities or developmental disabilities. So if you have beneficiaries that have special needs, you need to be mindful of that. You don't want to just leave them a policy that they can't manage. I have a client, her son has a developmental disability. He's 17, but has the maturity of a 5-year-old. You can't leave him a $100,000 life insurance policy. And so even in that instance, you would have to create a trust. And we'll talk more about that later. Are you leaving some money or benefits to a senior citizen or someone that's on Medicaid, that's a part of long-term care? It's important to be aware of that, because if they're on Medicaid and they get this huge asset, that may impact their ability to qualify for Medicaid. And so all of that's just important to consider when you're thinking about what are your assets or your property and who are your beneficiaries. And as you're thinking about your beneficiaries, consider the special considerations that you may have to make depending on who your beneficiaries are. Step 3 in the process is identifying the tools that you can use to get your assets to your beneficiaries should you pass away. And so the most common one is creating, the full name is last will and testament, but creating a will. And basically the will is a document or paperwork where you identify who your beneficiaries are, the people that will get your assets or property. You identify what they will receive from your assets or your property. You identify your personal representatives. Other states call it an executor, somebody who manages the affairs. In the state of Florida, we call it a personal representative. And it's just who you want your property to go to. That's the will. That's the will. Who do I want my property to go to? And you can give specific gifts. So I want person A to get my blue ring. I want person B to get my house. I want this person to get my car. I want this person to get my expensive purses. That's what the will is for you to just list out who you want your property to go to. But in the state of Florida, it needs to be signed by 2 witnesses. Everybody needs to be there at the same time. You also want to make sure it's notarized as well. The next option is a trust. And so I mentioned this briefly earlier. So the trust, another legal document, another form, another sheet of paper, where you're basically saying, I'm putting this property in the trust. It could be a house, it could be a life insurance policy, it could be money in the bank, whatever it is. And you designate a trustee, someone you trust, who will manage your money and carry out your wishes. And then you also identify your beneficiaries. So I'll give you an example. For me, I have a minor child, she's 13, so I can't leave Alyssa my $1 million life insurance policy. So I have a trust for Alyssa. My trustee, the person who would manage it, would be my husband. My daughter Alyssa is the beneficiary, and I can be very specific how I want that money spent on her. I want her to have a car when she's 16. I want her to be able to go to college and you write the check for her. I want you to be able to pay a down payment toward her first home, and then once she's 30 and responsible, whatever remains, just get it to her letter hand. So the trust is quite different from the will, because the will you're just saying, I want Candace to have this. I want K-Nell to have this. The trust is, I want my trustee, the person I trust who's trustworthy, to give this property to my beneficiaries, and this is how I want them to get it to me. So there's quite a difference there, but the trust is very powerful and can allow you to be able to have assets for the next generation if you have enough money and property. Any questions about anything that I've discussed so far? Yes. Sure.
Just thinking about the trust, like I said, brings the kids, it gives them motivation to go to school, because they realize if they don't go to school, they may not get it. So it could be a motivation. You know, by you stipulating you don't go to school, you know, well, I can't get the money. Where could it give them that motivation to go to, or whoever?
Absolutely.
It's stipulating how you want to be handled and give them motivation. So I like trust.
Absolutely, and I agree with that, yes.
I have a question. When the part where the friend, you want a friend to have, what is the likelihood of getting a will overturned? The reason why I'm asking, I've heard stories where a lady had this good friend, neighbor, and when she became ill, the neighbor really looked after her. No family members came by, but when she passed away, she had her neighbor in her will to really get everything. But the family going back.
There's resistance.
So what is the likelihood of that being over time?
So what I recommend with any will, it can be contested, so that's the term that we use. People don't like that they've been disinherited. People don't like that Bobby got the motorcycle and I want the motorcycle and I don't even ride motorcycles. And so what you can do is go to the court system and say, hey, I don't believe my mom or my dad had the ability to draft this will. They didn't have a sound mind. Or you can say, hey, this will wasn't properly executed. Or this person coerced or persuaded my loved one to put them in the will, but it wasn't really their wishes. So you can always, call it a will contest, you can always contest a will, and in those instances, it's up to the court to get all the evidence to determine if it's a valid will, if the person had the right and sound mind when they created the will, and whether or not the will are the true wishes of the person that has passed away. But even with family members, you know, as an example, someone consulted with me about a probate in St. John's County. The probate has been going on for 7 years. This person is passed away 7 years ago, family fighting over, well, dad wanted me to have this and dad wanted me to have that. And someone produced a second will. I don't know where that one came from. And so unfortunately, when you're dealing with property and assets, greed can kick in. Unfortunately, I see it a lot in probate cases, or I feel like I should be entitled to this, even if I wasn't in the picture the whole time while mom was under hospice care, or in the nursing home. I feel entitled to whatever. And so I'm going to make a big fuss about it. And so unfortunately, that does happen if you leave it to a friend, if you leave it to loved ones. And so if you're creating a will, it's important to just make sure it's properly executed, properly documented. I know when I draft wills, because I just had that exact example. A client came to me, wanted to leave property to a family friend who's been there and been helping them out, wanted to disinherit 2 children. And so I documented everything, because I told them, oh, you know this is going to be a fight. Should you pass away, they're not going to be taking this lightly. Even if you haven't seen them in the past 20 years, they still feel entitled because they have your blood running through their veins, right? And so as an attorney, I make sure I document everything. And if it gets to the point where we even need to record the will execution when they're signing the paperwork, I'll go to that level as well, because it can always turn into a fight. And then it will be up to the judge to determine which will is valid if there's multiple wills, or what were the wishes of the person who has passed away.